I think one of the challenges with trade union rights as human rights is that there's sort of a very specialist body of jurisprudence that's built up around it, particularly through the International Labour Organization. So I'd like to start with a bit of a presentation. First things first, I'm Jeff Sissons. I'm the General Counsel at the New Zealand Council of Trade Unions. And this presentation I've extracted from a larger conference paper that I've worked on with Edward Miller, who some of you will know. He's the strategic advisor at First Union, but he's also been quite involved in human rights stuff up in Auckland. Edward sends his apologies, but he's currently at the ILO in Geneva. I'll make a disclaimer first up that what I'm talking about here isn't really CTU policy yet. I don't think we'll be too far off it, but the officers haven't signed off on this. And for the purposes of these opening remarks, I want to focus on the question of whether collective bargaining should be recognised as a fundamental human right and as part of freedom of association. And first point to make is that under current New Zealand law, it's not really. And you'll hunt in vain looking through the Bill of Rights for it. I'd like to argue that this needs to change, and I'll take you on a whistle-stop tour of international treaties. If this is all stuff that you know, I'd like you to cue me by yawning loudly, and I'll start flicking forwards. And I want to look at some developing jurisprudence in Canada and in Europe around this stuff. For the trade union movement and for workers as a whole, this is a really fundamental issue. And the most vivid example that I want to take you through a little bit is the Hobbit Amendment. Yes, we're still talking about it. Yes, we're still grumpy about it. And I don't want to go through the gory political details, but I want to talk a little bit about that from a rights-based and a process-based analysis. Finally, I'd like to make a few modest proposals for how we might fix some of these issues in the Constitution. And we can treat that as a good discussion jump off, I think. So I'll rip into it. Firstly, Universal Declaration of Human Rights very simply says everybody has the right to form and join trade unions for the protection of his, sorry about the gendered language, interests. And although collective bargaining itself isn't mentioned, several commentators have said it seems clear that the frame is included, that it be part of freedom of association. And I go into that in a bit more detail in my paper, which I think will be sent out. The International Covenant on Civil and Political Rights, sorry for the slightly busy slide. Everyone shall have the right to freedom of association with others, including the right to form and join trade unions, and no restrictions should be placed on this other than those which are necessary in a democratic society in the interests of national security or public safety, public order, protection of public health or morals, or the protection of rights and freedoms of others. There are restrictions on armed forces and the police, and there's a specific reference to ILO Convention 87, which I'll come to. The ISESCA, Article 22, is very similar to Article 8 of ISESCA is very similar to Article 22 of the ICCPR, but it also sets out the right of trade unions to establish national or international federations or confederations. And it sets out a right to function freely subject to no limitations other than those prescribed by law. And it also interestingly sets out the right to strike, which isn't in the ILO instruments. Now, New Zealand ratified both of these on the 28th of December 1978. As we discussed last night, it was done under the Muldoon government. Now, what's interesting about these is, although, as you'll note, neither of those articles contain any specific reference to collective bargaining, the Covenant Oversight Committees have both handed down decisions making it clear that both of the core covenants do in fact protect the right to bargain collectively as an inherent and inseparable aspect of freedom of association. And from the perspective of the International Human Rights Committee, collective bargaining is both an economic right and a civil right. So this is what the UN bodies are saying about this. So you can argue that there's a false distinction being made by treating collective bargaining as a economic, social and cultural right rather than a civil and political right. I think it's both. I want to introduce you to the ILO. The ILO is one of the oldest parts of the United Nations and one of the surviving bits of the League of Nations. It was formed in 1919 in the wake of in the Treaty of Versailles, in the wake of the First World War. And it was really driven by the chaos that the world had been pushed into, and moved by sentiments of justice and humanity and the desire to secure the permanent peace of the world was one of the original aims of it. 185 of 193 of the UN member states are also ILO members. There's a few holdouts like North Korea, but unlike other United Nations bodies, the ILO is tripartite, and that's a really important difference. It also has representatives of workers and of employers' organisations, the most representative bodies. So the New Zealand Council of Trade Union is the representative workers' body to the ILO. And the purpose of the ILO is really to advocate for workers' rights and employment rights and to regulate the world of work. And to that end, it develops non-binding recommendations and binding conventions, which are international treaties. And New Zealand's ratified, at last count, 51 of those, including 6 of the fundamental ones. And right from the start, really, the ILO has recognised the fundamental nature of collective bargaining as a right in the world of work. And that's recognised in the Declaration of Philadelphia in 1944, which became appended to the ILO Constitution. It's also recognised most recently in the Declaration of Fundamental Rights and Principles at Work, which is really the ILO's restatement of its mission. In the context of the Declaration, collective bargaining was clearly deemed to be equivalent in stature and concern with issues like employment equity and freedom from child and forced labour. So I want to talk about 2 really important fundamental conventions, Convention 87 and Convention 98. To super summarise these, Convention 87 provides protection for workers and employers' organisations from interference with their creation and their activities. Convention 98, the right to organise and collective bargaining, it regulates the interactions between workers and employers and their respective organisations. It provides protection from discrimination and employers seeking to control the unions in various ways. Importantly, Article 4 commits signatories to members to encourage and promote the full development of the utilisation of machinery for voluntary negotiation with a view to the regulation of terms and conditions of employment by means of collective agreements. This is the ILO principle, really, that says collective bargaining is how you should regulate terms and conditions of employment. And with a bit of pushing, and I acknowledge Margaret's work here, this convention has now been signed up to by the New Zealand government, although they haven't signed up to Convention 87 at this point. The New Zealand Bill of Rights Act, I'm going to assume that everybody's fairly well familiar with this, and I won't go into it in great detail, except to point out that currently there's rights of freedom of peaceful assembly, freedom of association, and freedom from discrimination in terms of rights in the world of work. And no mention is made of collective bargaining rights. The Employment Relations Act, and I acknowledge the major architect of the Employment Relations Act here, one of the objects of the Employment Relations Act is to promote observance in New Zealand of the principles underlying International Labour Organisation Convention 87 on freedom of association, and I note that it's misnamed in the bill, in the Act, and Convention 98 on the right to organise and bargain collectively. A point which the courts have made, and it's worth noting here, is that the object of the Act is to promote observance with the principles underlying the conventions, rather than the actual conventions themselves. And there's been a slightly odd judgment from the Full Employment Court in Epic Packaging Limited, where they said that what's addressed by the object is the promotional observance of the underlying principles of the conventions, rather than adherence to the words themselves or the way in which they've been interpreted by the ILO, by the Committee of Freedom of Association. And with due respect to the court, it's a little mysterious. And we'll come back to the Employment Relations Act and discussing the Hobbit amendments. So, I just want to make mention of the presumption of consistency, which is really, when the courts interpret legislation, they will say, subject to the words of the legislation and consideration of any special local circumstances, they'll always seek to develop and interpret our laws in accordance with generally accepted international rules to accord with New Zealand's international obligations. I see it as running somewhat parallel to the obligation to interpret the law in terms of the rights and freedoms contained in the Bill of Rights Act. There's a very interesting question as to how those two interact. Now, the New Zealand law around collective bargaining currently, in a case called Ecatone versus Alliance Textiles, the Court of Appeal, the major judgment was delivered by Justice Galt, and he said, obiter in fact, not in the course of the actual reasoning for the decision, the rights to elect and pursue collective bargaining arise out of, but are generally not regarded as elements of the freedom of association. So he cites two cases in relation to this principle, proposition. Collymore and Attorney General, which is a 1970 Privy Council case from Trinidad and Tobago. There's an interesting question here as to whether this is actually binding law on New Zealand. The Court of Appeal has said in the Crown against Chilton that the law's not clear on this as to whether Privy Council cases in other jurisdictions prior to the enactment of the Supreme Court are actually binding on New Zealand. They punted a bit on that, but they didn't need to decide it. It remains the law in Trinidad and Tobago, and no right to collectively bargain arises from their constitution. But I want to talk to you about two really interesting cases from Canada and from Europe. Firstly, the British Columbia Health Services case. The full site is in the paper, and there was a appeal brought before the Supreme Court of Canada about the constitutionality of Part 2 of the Health and Social Services Delivery Act 2002. And because they considered it violated the rights to freedom of association in the Canadian Charter on Rights and Freedoms. Now, the Health and Social Services Delivery Act was a really pernicious piece of legislation. It gave employers greater flexibility in organising relations with employees. In some cases, it allowed them to do it in ways that weren't possible under the current collective agreements. And it introduced changes in things like transfers, subcontracting, employment security, layoff and bumping rights. And Section 10 of that Act also invalidated any part of a current or future collective agreement that was not in conformity with the new Act, any collective agreement aiming to amend these restrictions. So we see some echoes of other stuff in this. And the legal issue faced by the court was to determine whether the guarantee of freedom of association laid down in Section 2D of the Charter protected collective bargaining rights, and if so, to decide whether the rights had been violated by the approved law. In ruling on the first point, the court overruled a number of earlier decisions, including one of the decisions cited in Ecatone. It recognised that the grounds called on in the past to exclude the right to collective bargaining from the guarantee of freedom of association could no longer be supported, because it would not be consistent with Canada's historical recognition of the importance of collective bargaining. Moreover, the court stated that collective bargaining is an integral part of freedom of association in international law, which can be used in the interpretation of guarantees in the Charter. The court stated that the sources most important to the understanding of Section 2D of the Charter are the ICESCA, the ICCPR, and Convention 87, all of which we've zoomed through. Because Canada had ratified all three, the courts recognised that these documents reflected not only international consensus, but also principles that Canada had committed itself to uphold, to take Sed's point from last night. Adams has said that BC Health Services may be seen as history to be a turning point in the way that collective bargaining is conceived and evaluated in Canada. Although long counted as a human right by experts and advocates, in Canada prior to the Supreme Court decision, it was neither treated by governments as a human right, nor recognised by the public as a human right. It was treated instead as if not exactly an ordinary partisan issue, no more than a statutory right, one which the political parties of the left may strengthen and expand, and parties of the right may contract and fetter. And I think there's real resonance with the New Zealand situation here. Even more dramatic and far-reaching is the 2008 case of Demir and Bakara versus Turkey. In that case, a Turkish trade union of municipal officials reached a collective agreement with a municipality. When the latter failed to fulfil its obligations under this agreement, the trade union initiated proceedings in the district court. The court ruled in favour of the union, but was subsequently overturned by the Supreme Court. And the Supreme Court denied the trade union's right to even engage in bargaining with the municipality. The Audit Court, as a result of this decision, ordered the trade union members to repay additional income that they had received under the now-defunct collective agreement. Mayors who had concluded collective agreements of this kind were prosecuted in both the civil and criminal courts for abuse of power. A member of the trade union and its president, Demir and Bakara, brought the case before the European Court of Human Rights. After an initial ruling finding a violation of Article 11 of the European Convention of Human Rights, the case was referred to the Grand Chamber of the Court at the request of the government of Turkey, which claimed that the court could not, even in matters of interpretation, put forward against it any treaties other than the European Convention on Human Rights. The Grand Chamber of the European Court, again, much like the Canadian Supreme Court, reversed a significant body of earlier jurisprudence to hold that the right of collective bargaining is an essential element of the right to freedom of assembly and association.